Hello, my name is Nicola and I'm a solicitor here within the family team at Curzon Green. If you're a parent, you'll know that life doesn't always run smoothly. Each month of the year brings its own challenges, and sometimes those challenges can feel overwhelming. Whether it's deciding which school your children will attend, making arrangements for holidays, or planning who is going to go to the next parents' evening or school play, family life can be stressful. And when parents are separated or going through a dispute, these moments can become even more difficult and strained. Holiday planning can be a particularly emotional and stressful time for separated families, especially when there are disagreements about where children should spend their time and whether they should be allowed to travel abroad. Ideally, parents will reach an agreement between themselves and plan in advance. But where that isn't possible, we can help by opening up clear and open lines of communication to help you try and reach an agreement that focuses on what is in the child's best interests. If it proves impossible to reach an agreement on a singular issue, like holidays, and non-court dispute resolution methods do not work, a parent can apply to the court for a specific issue order to resolve a particular dispute. Where there is a wider disagreement around contact and where children should live and with whom they should spend their time, parents can look to agree a parenting plan. But where communication breaks down entirely, or there are serious safeguarding or welfare concerns, it may be necessary to instead apply for a child arrangements order. If you make an application, the court will be guided by what practitioners refer to as the welfare checklist, which can be found in the Children Act of 1989. The courts start with the presumption that the involvement of both parents is generally beneficial to the child, unless there's evidence to the contrary. And the court will not make an order unless it believes doing so will improve the child's situation. These applications take time, so it's important to act early, particularly around the holidays. As we approach the end of the year, we are often approached by parents who are struggling to agree schooling decisions for their former partner, particularly if a child is due to start primary or secondary school and an application needs to be made. If both parents have parental responsibility, they must try and agree on major decisions like which school a child attends. If they can't, either parent can apply to the court, again for a specific issue order, asking the court to decide the issue. Alternatively, they could apply for a prohibited steps order, asking the court to prevent a parent from taking a specific course of action. The court will make a decision based on what they believe is in the child's best interests. Court should always be seen as a last resort, and as solicitors, we can help you by gathering the relevant information to build your case and to support informed decision-making. These situations can be resolved more easily and with less stress when handled in a calm and timely way. If you'd like to speak in confidence about your options, please feel free to get in touch.